A courtroom morning, calm surface, heavy stakes underneath. Watch closely how swiftly these hearings move. One wrong answer, one missing detail, and someone's future pivots instantly.
Good morning, Mr. Warren. Good morning. You're Valerie Hale. And will your client waive the formal reading of the indictment?
No, yeah, put it on the paperwork. Yeah, wrong, Judge.
Driving while intoxicated with child under 15. That's not just a traffic offense. That's a state jail felony with emotional weight attached. Judges don't just hear facts. They hear consequences. Would you call this a moment of accountability or regret?
Okay. All right, Ms. Hale, in clause number 25, DCCR 0573, you're charged with a state jail felony offense of driving while intoxicated with a child under 15, and that's from March 13th of 2025. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand? And do you understand, if I follow the agreement that you made with the attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. Order to pay a $1,000 fine and to follow all of the rules and conditions of probation, including having an auto ignition interlock device on your vehicle. Do you understand? Do you have one now? Okay, I was about to say you should already have one, and so that'll be part of your probation. At least.
Here's a turning point. A guilty plea isn't just words. It's a permanent acknowledgement. I did it. Notice how the judge verifies competency, understanding, and voluntariness before locking in the decision. No confusion allowed. This moment is final.
At least for some amount of time as well. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. Submitted. Is there any evidence that Ms. Hale's not competent? What kind of history, if any? Okay. All right. So, Ms. Hale, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Waive the pre-sentence report, find sufficient evidence to find you guilty, and at this time follow the agreement that you made with the district attorney and find you guilty of driving while intoxicated with a child passenger. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation, including continuing with that interlock device until further order of the court. Okay? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment. It'll provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Barber. And so, this is for you, for this probation, this is for all practical purposes, your case here in court is over. And you'll be able to serve that 2 years while you're out on probation instead of in the state jail prison. And if you do everything correctly, you'll never be back in court. The other side of that, though, is if you violate...
New case, new energy. This one is continuous violence against a family member. A charge that signals repeat behavior, not a one-time mistake. And look how quick the plea comes. Guilty, no pushback, no hesitation. Why so fast? Strategy or surrender?
Any condition of probation, you can be brought back into court and you could be facing that 2-year sentence that you've agreed to. Do you understand? All right, you just need to have a seat here in the courtroom. Probation, she's in at that desk right there. She's going to call you up when she's ready to go to work. Okay? Yes, ma'am. Good luck. Good morning. Are you Christopher Morale? Yes. And Mr. Parker, will your client waive the formal reading of the indictment? Yes. Mr. Morale, in cause number 25, DCCR 0466, you're charged with the third-degree felony offense of continuous violence against the family from February 8th, 2025. How do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they've charged you? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you sign these, did you go over them with Mr. Parker?
Yes.
And do you fully understand? And you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal. And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, including entering and successfully completing an anger management program. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State Tenders Number 1. It's admitted. Is there any evidence that Mr. Morale is not competent? And as a condition of your bond, is it already, you should already have a condition that you're not to have any contact at all with Alonda Kelly. Okay. So I want to make sure that you're still under that bond condition, that it will likely be a condition of your probation as well. So if you violate that and have any contact or communication with her whatsoever before sentencing, then I don't have to accept this agreement. Things could be much worse. Do you understand? All right, so I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk over there. All right, we'll see you back at 10. Thank you, Mr. Parker. When did you smoke marijuana last? So here's the thing. You need to tell me the truth, because I'm going to get a quantity amount, not just that you're positive, but I'm going to get how much is in your system. And so I need to know when you smoked it last, so that if I find out next time it's not going down, things are going to be worse. So when did you smoke? When did you smoke? Day before yesterday. So that's why you weren't wearing your patch. Right. I know, that'd be really convenient if you had 2 felonies and you didn't have to wear a drug patch and you could smoke marijuana 2 days before. It'd be pretty convenient, wouldn't it? So you're going to have a drug patch today within 24 hours. No, the first one will be positive, obviously. If the next one is not going down, then your bonds in each of your cases will be raised and you will be back in custody. No questions asked. You understand? So you have 24 hours. I want you to get confirmation of that to your bondsman. Even though you've paid your bondsman, they're still your bondsman. They're still going to give you, just because you paid them off doesn't mean they're not your bondsman anymore. Okay, so even if you pay off the other one, you're still out on bond. You're still required to keep in touch with them. They're the ones that will help you figure out when your court days and all of that stuff. So don't stop communicating with them, because even though you've paid them, they can get off your bond and you can go back to jail. So keep up with everything you're supposed to. I want proof to them by tomorrow or this afternoon that you have the drug patch. You need to make sure it's switched.
Now the room tightens. The judge zeroes in truth, timing, and accountability. Marijuana 2 days before court. Bold or careless. The court doesn't punish the drug. It punishes the disregard. This is where defendants sink or swim based on honesty alone.